Yes, start. Having heard learned counsel for both the parties, it is important to first set out the reference order of this court dated 8/11/2016 in Sampath Kumar versus Kale Yadav and others SLP number 33677 2015. A division bench of this court, after referring to Speaker Haryana Vidhan Sabha versus Kuldeep Visnoy and others 2015 12 SCC 381 and Speaker Odisha Legislative Assembly versus Keshri 2013 11 SCC 794 then held. We have considered the aforesaid submissions of both the learned Attorney General and the learned counsel appearing on behalf of the petitioner. We feel that a substantial question as to the interpretation of the Constitution on the facts of the present case. It is true that this court in Hulund case laid down that a quatermate action would not be permissible and Sri Jayant Bhushan, learned senior counsel, appearing on behalf of some of the respondents, has pointed out to us that in Ayer's advanced law, a quatermate action is the right to be protected against anticipated future injury that cannot be prevented by the present action. Nevertheless, we are of the view that it needs to be authoritatively decided by a bench of 5 learned judges of this court as to whether the High Court exercising power under Article 226 of the Constitution can direct a Speaker of a Legislative Assembly bracket acting in quasi-judicial capacity under the 10th schedule bracket to decide a disqualification petition within a certain time and whether such a direction would not fall full of the quatermate action doctrine mentioned in paragraph 110 of Khito case. We cannot be mindful of the fact that just as a decision of a speaker can be corrected by judicial review by the High Court exercising jurisdiction under Article 226, so prima facie should by a speaker be judicial review so as not to frustrate the object and purpose of the 10th schedule, which has been referred to in both the majority and minority judgments in case. The facts of the present case demonstrate that disqualification petitions had been referred to the Honorable Speaker of the Telangana State Legislative Assembly on 23rd August 2014, and despite the hopes and aspirations expressed by the impugned judgment, the Speaker has chosen not to render any decision on the said petitions till date. We therefore place the papers before the Honorable Chief Justice of India to constitute an appropriate bench to decide this question as early as possible. Para. We would have acceded to Mr. Madhvi plea that in view of this order of a division bench of this court, the hearing of this case ought to be deferred until the pronouncement by a five-judge bench of this court on the issues raised in the present petition. However, we find that this very issue was addressed by a five-judge bench judgment in Rajendra Singh Supra and has already been answered. Unfortunately, the decision contained in the aforesaid judgment was not brought to the notice of the division bench, which referred to the matter of five judges of this court, though Rajendra Singh Rana Supra was short to be distinguished in Kuldeep Bishnoi Supra, which was brought to the notice of the division bench of this court. Para. It is important to the first set out what was decided in the majority decision in Supra. A bench of three learned judges of this court set out in paragraph 24 of the judgment several questions that require decision in that case. Full stop. We are directly concerned with the questions E and F, which are not set out and which read as follows. On the contentions raised and urged at the hearing, the questions that fall for consideration are the following: that the deeming provision in paragraph 6(2) of the 10th schedule attracts the immunity under Articles 122 and 212, the Speaker and the Chairman in relation to the exercise of the powers under the 10th schedule shall not be submitted to the jurisdiction of any court. Full stop.